Good morning, everyone. My name is Tim Sarsfield. I'm a partner in the Thompson Coburn Labor and Employment Group. I'm located in St. Louis, Missouri. Today, I and my fellow speakers are going to talk about the Family First Coronavirus Response Act. So that you know, this is the first of a series of webinars that are going to be hosted by Thompson Coburn, dealing with a wide range of legal issues with a particular emphasis on COVID and responding to COVID, this fall. And we do hope that you like us so much that you will tune in for the rest of the webinars. But always remember, we were first, so you like us best. Before we get to the presentation, I need to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these questions during the webcast, but if fuller answer is needed or we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. This webinar is accredited in California and Illinois for 1.5 hours of general CLE credit. Here in Missouri, we're credited for 1.8 hours of general CLE credit. 1.5 hours of general CLE credit in Texas is pending. This webinar is also accredited for 1.5 hours of SHRM credit and 1 hour of HRCI credit. CLE credit is based upon attendance for the entire 90 minutes. So from time to time, you will be required to click on a pop-up screen to reflect your continued engagement. Certificates will be sent out to qualified attendees within 48 hours of the conclusion of this webinar. We do value all of your opinions and appreciate your participation in this course. So, as I said, today, myself and Colin and Amy and John, we're all going to talk about the Family First Coronavirus Response Act. I'm going to start off with just a broad overview of the law. Later on, Colin is going to talk about the regulations that really put some meat around this law. And then John and Amy are going to talk about what the states and local governments are up to. So, this law went into effect back in the spring of 2020, so about 7 months ago, which I don't know about you folks, but it seems like about 70 years ago, but it was only about 7 months ago. This is a interesting law in that it has a sunset provision. I personally cannot think of a labor and employment law that previously had a sunset provision. In other words, this law is scheduled to end on December 31st, 2020. Will it be extended? I don't know. I don't think it'll be extended before the election. After the election in November, December, before a new Congress shows up, perhaps before a new president shows up, will it be extended? I don't know. But as of right now, it is scheduled to end December 31st, 2020. This is also a unique law, and it is the first federal law that I can think of, or in fact, I know this is the first federal law that provides for paid sick leave under certain circumstances. Many of you have adopted voluntarily paid sick leave programs. Some of you have unions and you've negotiated paid sick leave programs. There are various states out there, as John and Amy will talk about, that have adopted paid sick leave programs, but this is the first federal law along those lines. In addition, it provides additional time off, protected leave, for people who meet certain qualifying conditions. I know a lot of the people on the phone today are familiar with the Family Medical Leave Act, and that you could make an argument that if I had come down with COVID or if I had to stay home and take care of my wife and I was otherwise an eligible employee under the FMLA, I would have had some protected leave, but this goes above and beyond that. For example, up until now, I'm not aware of any federal law or any state law or even any local law that would have said that you needed to give time off to someone who couldn't come to work because their child's school was closed. Now, one thing that I do want to stress here is the Family First Act does not preempt the field. I know there are some benefits people here or that are listening, and you're familiar with ERISA, and you're saying, yeah, doesn't that get rid of all the state and local laws? Well, ERISA sometimes does, but this law does not. And so it's really important that you listen to John and Amy, because even if you're not covered by this law, or even if you are covered by this law, you may very well have additional obligations as a result of various state laws or various local laws. And along those lines, if, for example, you have a union and you've negotiated paid time off with them, this will be in addition to any pre-existing contractual obligations that you might have. Now, I've said this a couple of times, but once again, this is a unique law in that most laws that I deal with, and I think that John or Amy or Colin deal with, you have to have a certain number of employees or above a certain number of employees in order to be covered by that law or to worry about that law. This is unique in that it does not apply to really large employers. You have to have less than 500 employees to be covered by this particular law. Another thing that I think is unique about this law is, for example, if you've dealt with plant closing, you need to have a certain number of employees at a particular site in order to be covered. If you've dealt with the FMLA, you have to have a certain number of employees at a particular site in order to be covered, or at least within a 75-mile radius. This is not a site-specific law. So how do you go about counting your employees? Well, it's 500 or less in the United States, anywhere in the United States. If you have less than 500 employees throughout the United States, you're covered by this particular law. Now, you do have to count, for example, your temp employees that are your joint employees. If you have employees on leave, you have to count them, et cetera. One thing, and I know we're focusing in on the Family First Act, but one thing that I would want to mention to everybody here is make sure you understand that when you have temp employees, you do have obligations towards those people under a whole wide range of laws. Now, in terms of figuring out whether you have 500 or fewer employees or more than 500, you start off with the basic proposition that each corporation is a single employer. So, for example, my son's name is Tom and my daughter's name is Katie. So you got Tom Inc. and Katie Inc. They each have 400 employees. They each would be covered by this law. You wouldn't merge the two. The fact that you have a corporation that owns another corporation, that doesn't automatically mean you merge the employees. So to use my Kate and Tom example, at the top of the heap, you got Dad Inc., and he's got 200 employees. You wouldn't add those 200 to the 400 in Tom Inc. or the 200 to the 400 in Katie Inc. We start off with the presumption that we are separate and distinct from each other. Now, once again, this is a unique law in that normally it's employees that want to pierce the corporate veil in order to take advantage of laws. So, for example, under the traditional FMLA analysis, if Tom Inc. had 40 employees at a particular location and Katie Inc. had 20 employees at a particular location that was within 75 miles, the corporations would take the position that nobody's entitled to FMLA leave. There's not 50 employees at either place or 50 employees of the same employer within 75 miles of each other. And so the employee would want to say, no, you should lump them all together. I can't think of a situation where an employee would want to say, you know what? There's more than 500 employees, really don't pay me, don't give me the time off. I guess it's possible that an employer might want to do a reverse piercing of the corporate veil. I wouldn't encourage that because that will just cause you all sorts of headaches down the road. Potentially, I guess, the IRS, because a lot of the money that's paid out you can recoup through tax credits, the IRS might come along and argue that, no, all of those corporations, my example, I had about 1,000 people out there. Thanks for giving them the time off, thanks for paying them, but you don't get the tax credit. I don't know if that's going to happen, but if it does, or if you wanted to argue, I'm not going to pay anyone, I'm not going to give them the time off because I'm going to count all 3 corporations in my example together, what they're going to do is, or how it would be analyzed, is under the FMLA's integrated employer test. Under the integrated employer test, separate businesses may be considered as a single employer if they are integrated, and there's 4 factors that are considered. And again, just as an aside, if, for example, you had a corporation with OFC, with government contracts that had OFCCP obligations, and you had another corporation that didn't have government contracts, and you were trying to figure out, well, is that other company, are they covered by the OFCCP? You would use this test. This is a test that all sorts of different agencies use, or a variation on this, to figure out whether various corporations are responsible for the other corporations' actions or non-actions. So first of all, you look to common management. Right? Common management can range anywhere from, maybe at the top of the heap, you have a vice president who has responsibilities for, or president who has responsibilities for 2 or more corporations. Most commonly, I think what courts and federal agencies look to is the day-to-day responsibility. So do you have a manager, to use my example, that's responsible for a facility at Katie Inc., as well as an establishment or a facility or a branch in Tom Inc. They also look to the relationship between the operations. Usually, at least in my experience, when you have a couple of corporations that are basically doing the same thing, they have different names and they're incorporated differently, but they're basically doing the same thing, that's more likely to end up with someone saying, yeah, they're all one big happy family. They're all the same corporation. Similarly, if you have 2 corporations where your product requires a 2-step process and one corporation is doing the first step and the second corporation is doing the second step, that traditionally will lead to a finding that you're probably just one big corporation. And then finally, if you have 2 corporations that are doing business with each other, does it look like you're doing things at an arm's length? So again, what you always want to do, and I know we're talking about the Family First Act here, but just with respect to other laws, always make sure that your business people understand if we're separate corporations, then we need to look like we're separate corporations in terms of how we do business with each other. Centralized control of labor relations is probably the single biggest factor in terms of whether you're an integrated employer or not. So I know that there are people on this phone that probably perform HR services for 2 or more corporations. Again, one of the things that you want to do is make sure you have like a shared services agreement so that your time is being billed out, so to speak, to the various corporations. The final and least important factor under this integrated employer test is common ownership or financial control. As I mentioned before, that doesn't automatically mean that you're going to be treated as the same corporation under the Family First Act, but if it is a factor. Now, one thing that I will say about this law is that it does not, I'm going to talk about why people are going to get paid under the law here in a minute. One big reason is, of course, if the person themselves has come down with COVID. But you're not paying the person because they have COVID. You're not paying the person because they have to stay home and take care of someone with COVID. You're not paying the person because they have to stay home because their child's school is closed. There has to be work available to them. So, for example, I'm pretty sure there are a number of people on this phone call that have folks that are on layoff right now. So you have less than 500 employees, and let's say you have 75 employees on layoff right now because of business-related matters. If one of them calls you and says, hey, I just diagnosed with COVID, under this law, you don't have to pay them. You're not paying them because they're sick. You're paying them because they're sick and they're unable to do work that would be otherwise available to them. And along those lines, here at Thompson Coburn, most people haven't been coming to the office, at least here in St. Louis, since about mid-March. Now, I'm sort of an old-fashioned guy who thinks computers are, a fad. So I've been coming down to work during the duration. But, for example, Amy and Colin, our associates here in the St. Louis office, I've sort of forgotten what they've looked like. They've been working from home this entire time. But the important thing there is they've been working from home. If Amy, for example, were to get sick but was still able to work from home, you wouldn't be paying her under this particular statute. So, what is the paid? There's two components to this. First of all, there's the paid sick leave. That's 2 weeks of paid sick leave at the employee's regular rate of pay. What's regular rate of pay mean? Well, Colin, I think, is going to address that. The regulation goes into some detail about what the regular rate of pay is. But you would pay them for up to 2 weeks if they were subject to a quarantine order, if they'd been advised by their doctor or a healthcare provider to self-quarantine, or if they were feeling sick and were seeking a diagnosis. Then there are people who are entitled to 2 weeks of paid sick leave at 2/3 their regular rate of pay if, for example, they had to stay home and take care of a sick husband or a sick wife, or take care of someone who was required to self-quarantine. You would also pay someone who had to stay home and couldn't work from home because their child's school was closed or because the daycare provider was not available. And then there's sort of a catch-all example. If you're experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services. I don't know that I've dealt with that particular one, but there is a catch-all. One thing that I would say is this is essentially a one-time deal. And what I'm getting to here is, let's say I had come down with COVID back in March, and I missed 2 weeks of work, and you paid me for those 2 weeks. Now you get to October, and my wife is sick, and I have to stay home and take care of her. I don't get another 2 weeks under this law. This is a one-time deal. Okay. The next thing that comes up is, or this is why it's different than the FMLA, for example, is if someone has worked for you for 30 days, There's no 1,200. There's no 1 year requirement. There's no 1,250 hours. If they work for you for at least 30 days, they can take an additional 10 weeks of paid leave if it's related to the need to take care of a child because their school is closed, or because the daycare provider is closed, or because the daycare provider simply won't provide services. So that's an additional 10 weeks of paid leave. And again, just so we're clear about this, if I came down with COVID and I missed 6 weeks because I was sick with COVID, you would pay me for the first 2 weeks. I might have additional leave available to me under the FMLA, but you would not have to pay me. On the other hand, if I had to stay home and couldn't work from home because my kids' schools were closed, you would pay me for the first 2 weeks, and then you would have to pay me for up to an additional 10 weeks at 2/3 my regular rate of pay. So the first 2 weeks, you basically are going to end up paying me 80 hours. Now, I think Colin is going to talk about this. The easiest way to do this would be to just pay somebody 40 hours for the first week, 40 hours for the second week, but you technically should be taking some adjustments or making some adjustments based upon their regular work week, but you don't have to pay them for more than 80 hours. You know, what about part-timers? For example, my wife is a part-time employee. Well, you figure out what their average hours are over a 2-week period of time. And again, there is this additional 10 weeks of paid leave if a school is closed or a daycare provider is not available. Now, it wouldn't be a law here in the United States if there wasn't an anti-retaliation provision or an anti-discrimination provision, right? You can't discriminate against someone or you can't retaliate against someone because they took leave under this law. I mentioned that this law is going to expire come December 31st of 2020. I don't think anyone would do this, but that doesn't mean come January 2nd you can settle accounts with people who earlier took leave. I do think the retaliation protections will continue past December 31st, 2020. We're already starting to see lawsuits being brought where people say, yeah, they got mad at me. And in particular, it seems like a lot of these cases are, you got mad at me and you took action against me because I had to take time off to take care of my child or maybe take care of someone that was sick. I don't know that I've seen cases where someone who actually had COVID has claimed retaliation, although those will probably come down the pike in the not too distant future. They mostly seem to focus in on the school, the school situation. The exact standards that are going to be applied, I don't know 100% how courts are going to analyze this. I think the safest course of action is you don't want to let the fact that someone took protected leave factor in any way, shape, or form into an adverse employment action. If they otherwise have bad attendance, that's fine, but you don't want to dump this on top of it. If they're a poor employee in terms of their productivity or the quality of their work, focus in on that. Make sure that when emails are flying around or memos are flying around, that the business people, the supervisors, yourself for that matter, don't be putting in there, and then on top of this, Tim missed 6 weeks because he had COVID, or Amy missed 6 weeks because she had to stay home and take care of her child. So that's sort of the broad overview of the Family First Act. And now I'm going to turn this over to Colin, who's going to talk with you about the regulations and the guidance that has been put out, which again, as I think I said earlier, really puts some meat to some of the things that I've been saying. So, I appreciate your patience, and I hope you enjoy the next speaker. In fact, I know you'll enjoy the next speaker. So, Colin, I'm handing it off to you.
Thanks, Tim. Now we're going to move into the exciting world of FFCRA regulations. We're going to talk through what the regulations do and how it's changed over the past 6 months. As Tim said, the FFCRA became effective April 1st, 2020. And on that same day, the DOL released its temporary rule implementing and clarifying the leave provisions of the FFCRA. April 1st was a very exciting day for all of us who had been following the FFCRA since it was first drafted. The DOL then issued some revisions to the regulations on April 10th. Now, the FFCRA was passed very quickly, and significant changes and revisions were being made up to the last minute, which means there are some gaps and oversights and more than one confusingly worded provision in the statute. The DOL temporary rule is meant to clarify and add detail to the FFCRA to give employers a sense of how to actually apply the FFCRA's leave provisions. However, a key point to remember as we discuss the regulations is that these were also developed and released on a very truncated timeline and without the opportunity for public comment. The temporary rule does answer many of the questions we had when the FFCRA was passed, but it also created some others. And not every provision is intuitive or entirely clear, so it's recommended that you have counsel review any planned FFCRA actions you want to take before carrying them out. So let's get into some of the specifics. What do the regulations tell us? Well, they tell us a lot. The temporary rule included over 120 pages of regulations and guidance about implementing and enforcing the FFCRA. And I want to give you a few highlights to show you how detailed the regulations are and what kind of information you can find there if you know where to look. As Tim mentioned earlier, one of the most important parts of the temporary rule was about teaching us to count to 500. So that means when you're deciding whether the FFCRA applies to your company, which employees do you count towards that 500 employee threshold, and from which state do you count? It's the temporary rule that told us to apply both the integrated employer test from the FMLA and joint employer test from the FLSA, as Tim said earlier. And it was the regulations that told us to do the counting at the time the qualifying employee takes leave. Now, as I've noted in previous webinars, this can lead to the odd situation where, for example, if employee A were to take leave on Monday when her employer has 490 employees, she's entitled to FFCRA leave because the employer has fewer than 500 employees. Now, let's say that the employer hires 15 people on Tuesday. So when employee B requests to take leave on Wednesday, she's not entitled to FFCRA leave because the employer now has 505 employees. And all this means that if you're on that border, sitting around 500 employees, you need to take a look at your roles whenever anyone requests FFCRA leave. The regulations also tell us how to interpret the qualifying reasons for leave, all 6 of them under EPSLA and the Emergency FMLA Act. For example, as Tim said, the temporary rule is what tells us that being unable to work because of a quarantine or isolation order, which is the subject of that first qualifying reason for EPSLA leave, this means that the order must be the but-for cause of the employee's inability to work. And if that relevant order also required the employer to close, the employee is not eligible for leave. There must be work for the employee to do to get FFCRA leave. And this is a big one, and one we're going to talk about a little bit more over the next few slides. The regulations also tell us how to determine the rate of pay for FFCRA leave by using a 6-month average of the employee's regular rate. Now, as Tim said, it's very important to note that when I say regular rate, I'm not necessarily referring to the employee's hourly rate. The regular rate here is the same as under the FLSA and requires the employer to add in things like commissions and non-discretionary bonuses. It's recommended to consult with counsel when determining the regular rate for your employees, as the calculations can vary significantly based on what compensation you provide and what compensation must be considered. How small businesses can exempt themselves from providing childcare leave. The regulations include a list of steps and findings that employers must make to qualify for the exemption. And they tell us that employers don't need to apply for the exemption. If you qualify under the regulations, all you need to do is keep the documentation described in the regulations, presumably in case you're later audited after taking the small business exemption. Now here's an interesting one, because it kind of goes against the language in the FFCRA. So who qualifies as a son or daughter of an employee taking childcare leave? Now the statute said an employee may take emergency FMLA leave to care for a son or daughter under 18 years old, whose school has been closed or whose childcare provider is unavailable due to COVID-19. However, the temporary rule clarified that the normal FMLA definition of son or daughter would apply to the statute. And this means that caring for an employee's son or daughter older than 18 years could be a qualifying reason for leave if the adult child is unable to care for themselves due to a mental or physical disability. So this is one of those places where the regulations clarify what the DOL considered an oversight in the statute itself. Here's another interesting and important provision. Which employees can be excluded from certain FFCRA leave provisions as an exempt healthcare provider or emergency responder? Originally, the regulations took a broad stance on this, essentially allowing the exemption to cover most employees who work in healthcare settings, including administrative staff. But over the next few slides, we're going to see how this has developed since the temporary rule. One of the things we find interesting about this one is that the regulations actually provided two definitions of healthcare provider. There was the expansive one for the exemption, and a more limited one for which healthcare providers could advise employees to self-quarantine. So if you're under an order to self-quarantine, who's allowed to make that order? But as I said, we're going to get into this a little bit more later on. How employees may take intermittent leave. They have to have the consent of their employer to take intermittent childcare leave and are not allowed to take paid sick leave on an intermittent basis. Now, the portion about not taking intermittent sick leave is kind of intuitive. If you test positive for COVID, we don't want you coming into the office at all until you are completely recovered. But the employer consent requirement for childcare leave was not something we necessarily saw coming. And this is also one we'll be talking about more later on because there's been a bit of a change. What documentation must employees provide to take leave, and when do they have to provide it? The regulations tell us that the documentation includes dates for which the leave is being requested, the reason the employee needs the leave, the identity of the healthcare provider or government entity requiring the employee to quarantine, and a statement that the employee is unable to work because of their qualifying reason for leave. And I like to put extra emphasis on that last part, the statement that the employee is unable to work because of their qualifying reason for leave. This is important because if later on you find that an employee was not entirely truthful about their reason for leave, you have a signed statement or an emailed statement, more likely, that they represented to you that this was a qualifying reason. And that's important if you're going to take action against that employee later on. For child care leave, there's also additional documentation. The employee needs to provide the name of the child, the identity of the school or child care provider, and another statement. This statement is that no other suitable adult is available to care for the child. All of these documentation requirements come from the regulations. And in addition to all of these topics we just discussed, the regulations tell us much, much, much more. We could do an entire webinar just going through the regulations, but I think I might be the only person who would enjoy that, so we'll move on. Now, 4 of these provisions, what it means to have work available, who qualifies for the healthcare provider exemption, how employees take intermittent leave, and when employees must provide documentation for taking sick leave, these garnered a lot of attention recently when they were invalidated by a federal judge in New York, which brings us to our next slide. The state of New York versus the United States Department of Labor. On April 14th, this is less than 2 weeks after the DOL temporary rule was issued, the state of New York filed a complaint in federal court, claiming that the DOL had exceeded its rulemaking authority with regards to the 4 provisions we just mentioned. Essentially, New York claimed that the DOL's interpretation would mean that far fewer people would be able to take FFCRA leave than Congress intended when it passed the act. On August 3rd, and this is 5 months after the FFCRA went into effect and just 4 months before it was set to expire, the court largely agreed with the state of New York's arguments and invalidated these 4 aspects of the DOL's temporary rule. I want to walk through these one at a time to give you an idea of how the court arrived at its rulings. And this is important, not only because it changed the assumptions we were operating on for more than half of the life of the FFCRA, but also because it gives us an idea of how courts may analyze new FFCRA regulations. Spoiler alert, there are new regulations, or any other forthcoming COVID-related employment laws and regulations. So first, let's look at the work availability requirement. The DOL's temporary rule excluded employees from taking FFCRA mandated leave if their employers did not have work for them to do. As we discussed on the previous slide, and as Tim discussed, this meant that an employer did not have to provide FFCRA leave to its employees if the employees were furloughed or if the employer was not operating, either because they were not an essential business during a government-mandated shutdown or because it was not economically viable to continue operations. The court, however, invalidated this provision, finding that it greatly and impermissibly affected the breadth of the statutory leave entitlements by excluding this large group of employees. Second, the definition of healthcare provider. As noted before, the DOL's temporary rule gave an expansive definition of healthcare provider, allowing employers wide latitude about which employees they could exclude under the healthcare provider exemption to the FFCRA. As the court put it, an English professor, librarian, or cafeteria manager at a university with a medical school could all be considered healthcare providers under the rule. And the court rejected this definition, finding that the statutory language required these exempted healthcare providers to actually be capable of providing healthcare services, not simply working for an employer who otherwise employed healthcare providers. Third, we have intermittent leave. The regulations require that the employer consent to an employee's taking child care leave on an intermittent basis. The court found that the DOL failed to fully explain why the employer consent is needed for intermittent leave when public health considerations aren't implicated. So essentially why intermittent leave for child care reasons needs employer approval. Without this explanation, the court ruled that employees should be able to choose whether to take child care leave intermittently, even without employer consent. And fourth, the documentation requirements. The temporary rule requires employees to provide documentation to support their need for leave prior to taking FFCRA leave. For example, as we discussed, providing the reason for leave, the duration of the leave, identifying the authority for the isolation or quarantine order. These all had to be provided before the employee actually took the leave. Now, the state of New York and the court, however, took exception to the prior to taking leave language, especially when applied to taking sick leave as opposed to child care leave. The court ruled that employees should not be required to give advanced documentation of a need for leave when that need isn't necessarily foreseeable. So the whole theme of the court's opinion is that the DOL's temporary rule excluded too many employees from coverage and made it too hard to actually take the leave mandated by the FFCRA. The court found that the DOL's interpretation created too many rules that weren't required or even foreseen by the statute. So what happened when the court issued its opinion? Massive uncertainty for employers. They didn't know if or when the DOL would appeal the decision, if the court's decision applied nationwide or only to employers operating in New York, how they should handle FFCRA leave now. Because remember, the court's opinion invalidated provisions of the regulations, but it didn't replace them with something new. And finally, whether other states and courts would soon follow suit. Which brings us up to speed with the current regulations on the next slide. Regulations Round 2. After the decision, the DOL cleared up some of this confusion, at least for a while, by issuing what it is calling revisions and clarifications to the regulations, which went into effect September 16th. Now, essentially, the DOL went through the court's order and addressed each of the invalidated provisions. Sometimes it revised the provisions to bring them in line with the court's opinion, but just as often it clarified as to why the regulations were going to stay the same. So now let's take a look at how the DOL responded to the court's opinion and what the law is on these four aspects of the FFCRA today. Again, we have the work availability requirement. Remember that the court said there was no basis in the statute for the requirement that the employer have work available in order for the employee to take FFCRA leave. While providing what it called a fuller explanation on its original reasoning, the DOL stated that it considers the FFCRA to in fact require the work availability requirement and reaffirmed that the qualifying reason for leave must be the but-for cause of the employee's inability to work. So, at least for now, the work availability requirement stands. This means that if an employer only needs to provide FFCRA leave if it has work for the employee to do. Second, we have the healthcare provider exemption. Now, this is one where the DOL did make the court's change, and this has a significant impact on employers who employ healthcare professionals, especially if you are currently relying on the healthcare provider exemption in the FFCRA. The new DOL regulations limit the definition of healthcare provider to an employee capable of providing healthcare services, which the DOL further defined as employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care. This means that any employees who do not meet this new definition and have been considered exempt under the previous FFCRA regulations, such as a hospital's administrative staff, can no longer be considered exempt from the FFCRA. These employees, if otherwise covered by the FFCRA, must be allowed to take EPSLA and emergency FMLA leave. Third, intermittent leave. The court said that employees did not need the consent of their employers to take intermittent child care leave. But the DOL's new regulations reaffirmed that requirement with one very minor clarification. Employees do not need consent when they take child care leave in full-day increments to care for children whose schools are operating on an alternative day or hybrid attendance basis, because the DOL does not consider that to be intermittent leave. So, at least for now, employees still need the consent of their employers to take intermittent child care leave under the FFCRA. And fourth, the documentation requirement. Remember that the court said you can't require employees to give advanced documentation for a need for sick leave under the FFCRA. The DOL acknowledged that there was an inconsistency within the regulations regarding notice to leave as compared to documentation. Notice only had to be provided as soon as practicable, while documentation had to be required prior to taking leave. So now the requirement on documentation is the same as for notice, as soon as practicable, which for some qualifying reasons like child care leave will likely be prior to taking leave, but for other reasons like experiencing symptoms will likely be as soon as the employee can give notice. Now in practice, this likely won't change much for many employers. Keep gathering documentation as soon as you know an employee has requested or taken FFCRA leave, and keep that documentation on hand. So there you go. 2 of these 4 provisions were amended. One, the healthcare exemption, was amended significantly, and 1, the documentation requirement, not so much. The other 2 are, at least for now, staying the same. And I hope you've picked up on the fact that I keep saying, at least for now. Is this the last word on the regulations, especially those 2 provisions where the DOL disagreed with the court? Maybe, but maybe not. The FFCRA expires in less than 3 months, which would make any further rulings or revisions difficult to release and implement. However, as Tim said, there is always the possibility that the FFCRA will be renewed and extended into 2021, so stay tuned for any further developments. Now, there are a few other sources of guidance from the DOL about FFCRA leave. Unlike the regulations, these aren't binding, but they do tell us how the DOL interprets the FFCRA and the regulations and how they're likely to enforce them. So let's briefly run through a few of these other sources of guidance. First, the DOL FFCRA poster. This is less guidance and more just a requirement. The poster is available on the DOL's website, and it must be posted in every workplace covered by the FFCRA. Now, this is true even if an employer is taking the small business exemption, you still need to post that poster. Now, it's meant to be a resource for employees to know their rights, but I wouldn't rely on it too heavily when employers are determining what they need to do to comply with the FFCRA. There are much better resources for that. Second is one of those much more useful resources, the DOL's FFCRA Q&A. The first set of about 10 questions released by the DOL were issued ahead of the regulations and before the FFCRA went into effect. And these have been a huge help in interpreting the FFCRA. The Q&A, which is published on the DOL's website, now includes over 100 entries. And there's a fairly large range of the types of questions that are included. Some of them are simple definition questions. Who is a child care provider? Some of them are more about how do you apply the FFCRA? For example, how do I compute my employee's average regular rate for the purposes of the FFCRA? And some others give requirements. What documents do I need to give my employer to get paid sick leave or expanded family medical leave? But some of the most helpful entries are actually the scenarios and examples. For example, my child's school is giving me a choice between having my child attend in person or participate in remote learning for the fall. I signed up for remote learning because I'm worried about my child contracting COVID-19. Since my child will be home, may I take paid leave under the FFCRA in these circumstances? And the DOL's answer, which none of us foresaw, was in that scenario where the parent chooses virtual learning for their child, the parent is not eligible for child care leave under the FFCRA. Now, many of these answers closely track the regulations, but give a much more natural and clear statement of the rules. You know, a paragraph of text is always going to be a lot easier to read and understand than a long list of numbered and lettered sentences. Other answers offer clarification well beyond the regulations, and I'm thinking in particular of that last question regarding child care leave and remote learning. This is the kind of answer you're really only going to get from the Q&A. Now, it is very important to note that these Q&A entries are regularly being added to and sometimes revised, so it's worth visiting on a semi-regular basis to keep current, especially on the more recently added entries, which tend to have more revisions. This is not the kind of resource you want to print out or save a hard copy to your desktop. If you want to check the Q&A, you should go to the DOL's website for the most updated version. And keep in mind, the DOL doesn't always tell you when it's made a revision, so make sure you're looking at it fresh each time. Now, the third resource is that the DOL has released some other coronavirus guidance that touches on the FFCRA, even though it's not directly applicable. For example, there's a similar Q&A on the effects of the COVID-19 pandemic on the FLSA, which includes one FFCRA-related question that is extremely important, and it's about FFCRA leave for exempt employees. Now, that entry tells us that taking FFCRA leave will not affect the employee's status as exempt from the overtime provisions of the FLSA. Specifically, it won't undermine the paid on a salary basis requirement for exemptions. This is especially important for employers who have exempt employees whose daily pay exceeds the cap set in the FFCRA. For example, remember that childcare under the Emergency Family Leave Act has a $200 per day cap on paid leave. So if your exempt employee is paid the equivalent of $300 per day and then takes emergency FMLA leave, you only need to pay them $200 per day and can subtract that $100 from their regular paychecks. Now, normally, this kind of deduction would lead to a loss of the employee's exempt status. But the DOL has made it clear that deductions caused by taking leave under the FFCRA will not impact the employee's status as exempt from the overtime provisions of the FLSA. Now, again, nothing we've talked about on this slide has the force of law. But until we hear otherwise, it gives the most complete view of what we can and cannot do under the FFCRA. So with that, I'd like to turn things over to John in California, who's going to discuss additional state and local considerations. John?
Thanks, Colin, and good morning to everyone from what is now a very smoggy California. You know, because it's not difficult enough to comply with the FFCRA, the Department of Labor regulations, and the ever-changing questions and answers, which, you know, they all appear to be a moving target and be changing almost daily, let's face it. We all have to be also concerned about the various state and local laws, executive orders, and ordinances, which in many cases expand the coverage of the FFCRA and the regulations in certain situations. And on top of these state and local rules, employers also need to take into account the paid sick leave laws of various states, cities, and counties, which in many cases add on to the paid leave that might be provided by the FFCRA. So I'm going to now turn to the state and local expansion of the FFCRA in California and in Colorado, and then Amy is going to talk about New York and some other states. So what's going on in California? Well, besides the fires, as you might expect, California is on the forefront of COVID-19 employment-related issues, as it seems to be on just about all employment issues. And as Tim stated, this also includes litigation involving leave under the FFCRA. We are starting to see claims and lawsuits filed, not only about people who have been furloughed or laid off due to the pandemic, but also from people who are claiming they're not getting their supplemental paid leave under the FFCRA. So it should come as no surprise to any of us who have California employees that California, once again, has expanded federal law, providing additional benefits to those provided by the FFCRA. So let's just take a look this morning at what California has done. On September 19th of this year, Governor Gavin Newsom signed Assembly Bill 1867 into law, which effectively eliminates the so-called big box exemption. As you know, and as Tim spoke about, the FFCRA only applies to employers with less than 500 employees, but that's not the case if you're a California employer. Because under California's new law, large employers, in other words, those with 500 employees or more, which are the so-called big box stores, must provide employees with COVID-19 supplemental sick pay. So you might ask, does this mean that this new law is applicable if I only have 500 employees in California? Unfortunately, the answer is no. The new law, the supplemental paid sick leave law, is applicable even if it's applicable if you have 500 employees in the United States and are doing business in California, even if you have only one employee in California. That employee, that lone employee, will be covered by this new law. In addition, the new law also covers certain healthcare professionals and emergency responders who would not otherwise be required to be provided with leave under the FFCRA. And although California's supplemental paid sick leave covers all employees, it's only available if the employee leaves the person's home or other place of residence to perform work for the employer. What does this mean in plain English? This means that the additional coronavirus supplemental paid sick leave is not available to employees who exclusively work remotely. Unlike the feds, however, the state of California has not yet provided any guidance on what this means. So we don't know if requiring an employee to come in from time to time, for instance, to handle paperwork or attend a meeting or even just to pick up their mail, qualifies a remote worker for this additional paid leave. I think the best practice here, while we're waiting for some regulations or guidelines or even questions and answers by the California Labor Commissioner, is to presume that an employee is eligible if she or he must leave home to perform any work for you. As I said, this law was effective on September 19th and is set to expire at the end of this year. However, because the law is meant to complement the FFCRA and to supplement it, I think we can all expect that if coverage under the FFCRA is extended past the end of this year, so will, California supplemental coverage be extended as well. So who is this law applicable to if you're an employer? The California supplemental paid sick leave only is available to employees who are subject to a federal, state, or local quarantine order, advised by a healthcare provider to self-quarantine or self-isolate due to concerns related to COVID-19, and/or is prohibited from working by the company due to health concerns related to the potential transmission of COVID-19. So what this means is that California's supplemental coronavirus leave only is available in connection with an employee's own health or own exposure to COVID-19. Unlike the FFCRA or many other local sick leave ordinances, it's not available to employees who must care for children, whose schools or childcare closed for COVID-19 related reasons. You might ask, how much leave is available under California's supplemental paid sick leave law? 80 hours for full-time employees. In other words, 80 hours for employees working at least 40 hours per week in the 2 weeks preceding the leave. Part-time employees with a regular weekly schedule are entitled to leave equal to the total amount of hours they normally are scheduled to work over 2 weeks. But if a part-time employee's scheduled hours vary, the employee is entitled to 14 times the average number of hours the employee worked each day in the 6 months preceding his or her leave. If a part-time employee works variable hours and has worked fewer than 6 months but more than 14 days, the employee is eligible for supplemental paid leave in the amount of 14 times the average number of hours for the same period. If an employee has worked for 14 days or fewer, he or she is entitled to supplemental paid leave equal to the number of hours worked. And how much do you have to pay the supplemental leave at? You must pay supplemental paid leave at the regular rate of pay for the employee's last pay period, or the state, or in California, as you know, we have local minimum wages, whichever is higher. However, there's a cap, which is the same as for the FFCRA, of $511 per day, or $5,110 in the aggregate. Now, if you have union employees, this new law does not contain a collective bargaining exemption. And please note that this is different from California's regular paid sick leave law and the numerous California local paid sick leave ordinances, most of which do contain such an exemption. The new law also, of course, contains a notice posting requirement, as does the federal law. California's new law requires employers to post the Labor Commissioner's Office's model notice in the workplace so that it's available for all employees to view. Probably you should put this in the same place you put your regular California and federal posters. But in addition, California's supplemental paid sick leave law provides that you also need to disseminate the notice by email if workers who do not frequent your workplace, as is the case for many of us right now with almost everyone working remotely. And last but not least, and because let's face it, we're talking about California, where nothing is easy in the employment arena. Employers also need to provide their employees with written notice concerning the amount of supplemental paid sick leave available to them under the supplemental coronavirus sick leave law. Now, how do you do this? You basically can do this in two ways, which are the same ways in which you have to provide notice to employees under California's regular paid sick leave law. Either you can put it on the itemized wage statement as yet a 10th item required in California, or you can provide it in a separate writing on the designated pay dates. So as I said, California has many local laws and ordinances governing the employment relationship, including separate minimum wage orders and separate paid sick leave. And the coronavirus situation, of course, is no different. So it's not enough in California that you comply with this new supplemental paid sick leave law, because you're now also faced with a maze of local laws and ordinances as well. In response to the pandemic, and since the since the FFCRA took effect in April, a number of California cities and counties have passed their own COVID-19 related emergency paid sick leave acts. These were generally aimed at eliminating the big box exception we talked about a few minutes earlier, and on filling the gaps of coverage for people employed by larger employers who are not covered under the FFCRA. The city of Los Angeles started the trend in early April soon to be followed by San Jose, San Francisco, and unincorporated areas of Los Angeles County, also in April. Since that time, over the next several months, Oakland, Long Beach, Sacramento, Santa Rosa, and San Mateo County also have enacted their own local ordinances. Given that most of these ordinances were enacted before September 19th, when California expanded coverage to include the so-called big box employers, many of these local ordinances will have little or no applicability, but you need to check on each one because some of them do provide additional benefits to workers. As part and parcel of the supplemental COVID-19 legislation signed into law by Governor Newsom on September 19th, a new law, AB 1383, amended the California Leave Act so that effective January 1st, 2021, it will apply to employers with as few as 5 employees instead of with 20 or more employees as the law currently provides. Okay, that's enough of California. That's more than enough. So let's talk about now Colorado, the Rocky Mountain High state. I mean, Colorado has been leading the nation, kind of trying to take away the mantle from California as being an employee-friendly state. Colorado, early on March 11th, enacted the Health Emergency with Pay, known as the HELP Act rules, requiring Colorado employers in certain industries to provide emergency paid sick leave under HELP. Then, on July 15th, Colorado enacted the Healthy Families and Workplace Act, the FHWA, under which all employers in Colorado, regardless of industry or size, are required to provide emergency paid sick leave to any employee who's not already covered under the emergency paid sick leave provisions of the FFCRA. Colorado employers also must provide paid sick leave in the same amount and for the same purpose as provided in the federal law. This provision is effective December 31st of this year. And in addition to the HELP and FHWA rules, beginning January 1st, Colorado has enacted its own paid sick leave law, under which all Colorado employees will accrue 1 hour of paid sick leave for every 30-hour worked. I should say that that's for employers in Colorado with 16 or more employees. Smaller employees, those with 15 or fewer employees, will not be required to comply with the new law until January 1st, 2022. And in addition, if that's not enough, Colorado also has implemented emergency paid leave after 2020, which expands the scope of the FFCRA. Beginning in January of 2021, employers must provide up to 80 hours or an amount equivalent to 2 weeks of employees' regular hours of supplemental paid sick leave during any public health emergency. So it's not just limited to COVID-19. The paid leave must be available for an employee to use for any of the following reasons: to self-isolate due to a diagnosis or symptoms of a communicable illness related to a public health emergency, to seek a diagnosis, treatment, or care, including preventative care, for the illness, or who miss work when a governmental health official or the employer determines that the employee's presence would jeopardize others' health. In addition, this leave will be available to employees to care for family members who must remain home for one of those reasons, to care for a child or other family member whose place of care or school is unavailable or is closed due to the public health emergency, including when the school or place of child care is physically closed but providing instruction remotely, or to avoid work due to a health condition that may increase the susceptibility to risk of the illness. And with that, I'll turn it over to Amy.
Thanks so much, John. I'm going to start out by discussing two more states, New York and New Jersey, that have passed COVID-19 specific paid sick leave laws, and I'll follow that up with a quick discussion of some other paid sick leave considerations. So, of course, New York has implemented an emergency paid sick leave law specifically in response to COVID-19. In effect, it is also an FFCRA expansion, and the law applies to all private and public employers in New York. If an employer is already subject to the FFCRA, the amount of leave available, which we'll discuss shortly, is only to the extent greater than the amount of leave that's available to the employee under the FFCRA. So what employees are eligible for paid sick leave under the New York law? They're eligible if they are subject to a mandatory or precautionary quarantine order related to COVID. Now, there are, of course, a few exceptions to this. So an employee would not be eligible for paid sick leave if the employee is asymptomatic or has not yet been diagnosed with any medical condition. The employee also would not be eligible if the employee is physically able to work remotely. Additionally, employees will not be able to get paid sick leave under the New York law if the employee is required to quarantine after traveling for non-work related reasons to certain places. So first, an employee cannot get paid leave if the employee travels for non-work related reasons to a country with CDC level 2 or 3 health warnings if the employee was given notice of those warnings. I was looking at the CDC's website this morning at the list of level 2 and 3 health warnings, and at this stage, this list is going to cover almost all international travel. So if an employee is traveling internationally for non-work related reasons, they most likely are not going to be eligible to take paid sick leave under the New York law. Additionally, no paid sick leave is required if an employee travels for non-work related reasons to a state with a positive test rate higher than 10 per 100,000 residents or with higher than a 10% test positivity rate over a 7-day rolling average. Looking into this list of states, it's pretty expansive at this point. It includes 35 states and territories that are listed. And if individuals travel to these states, they're required to quarantine for 14 days. But if they're traveling there for non-work related reasons, they are not eligible to receive paid sick leave under New York law. So, for example, Nevada is included in the list of current states. And if you have an employee who goes to Las Vegas for a bachelor party, he's required to quarantine for 14 days upon his return to New York. And while we all hope he had a great time and a lot of fun at his party, he would not be eligible to use emergency paid sick leave to cover his absences. How much paid sick leave that the employees are entitled to under New York's law is going to depend upon the size of the employer and the employer's yearly net income. So if the company has 1 to 10 employees and their net income is less than $1 million, employees are entitled to unpaid leave until their quarantine order ends. If the employer has 1 to 4 employees and a net income of more than $1 million, the employee is eligible to receive 5 days of paid sick leave plus unpaid leave until the quarantine order ends. If the employer has 5 employees and a net income of more than $1 million, the employee is entitled to 5 days of paid sick leave plus unpaid leave until the quarantine order ends. And if the employer has 100 or more employees, the employee is entitled to 14 days of paid sick leave. Any employee who is taking leave under New York's law is going to be entitled to job protection. Employees also have the option, instead of using paid sick leave under New York's law, to use any other accrued paid leave, or the employee, I don't know why they would do this, can choose to take unpaid leave during the duration of their quarantine. Something that's notable about the New York law is that it doesn't contain a sunset provision. So it really remains to be seen when these provisions will no longer be in effect for New York. New Jersey has an existing paid sick leave law, but it's amended the law to expand the permissible reasons for taking paid sick leave. So now, employees are permitted to take leave during epidemic-related emergencies for a couple of reasons. The first is a determination that the employee's presence in the community or a family member needing the employee's care jeopardizes others' health. Employees are also permitted to take leave during epidemic-related emergencies if the employee is under isolation or quarantine or caring for a family member who's under isolation or quarantine due to suspected exposure to communicable disease. Again, notably, there's no sunset provision in this amendment to New Jersey's law because this expansion is going to apply to epidemic-related emergencies in the future. And I know that that's not something that any of us wants to think about right now, but it really goes to show how much the last 6 months have affected our lives, that we're thinking about how we need to enact laws that can apply to situations like this in the future. I'm going to take a minute to talk about some other relevant paid sick leave provisions because in addition to the COVID-19 specific paid sick leave laws that we've seen some states pass, there are many other states that have pre-existing paid sick leave laws that require employers to provide paid sick leave to their employees. These laws may be applicable to employers who are not covered under the FFCRA. Generally, these laws are going to provide that employees must accrue a certain amount of paid sick time for hours worked. So, for example, in Arizona, employees are required to accrue 1 hour of paid sick leave for every 30 hours worked. Alternatively, many of these laws provide that employers can provide their employees with a lump sum of paid sick leave at the beginning of each year. And generally, with these laws, there's a cap on how much paid sick leave an employee can accrue in a year. This cap is generally between 40 hours and even up to 54 hours of paid sick leave. Generally, under these laws, employees can take leave for reasons that are similar to FMLA leave. So for the employee's physical illness, injury, or another health condition, for the employee's diagnosis, care, or treatment, or if the employee needs to care for a family member with a mental or physical illness, injury, or health condition. So of course, these reasons that I've just mentioned may be utilized by employees in the context of this pandemic. If the employee has been diagnosed with COVID, they may need to take and be able to take paid sick leave under these laws. But to call back to the beginning of the webinar, Tim discussed that the FFCRA doesn't apply if there's not work available for the employee. So if the employee's place of work is temporarily shut down, the FFCRA's paid sick leave provisions would not be applicable. A number of states with existing paid sick leave laws, though, permit their employees to use paid sick leave when the employee's place of business is closed by an order of a public official for a public health emergency. So even though employees, and even if the employer is subject to the FFCRA, an employee in one of these states may be eligible to use their paid sick leave because the business is shut down by an order of a public official. These states include Arizona, Michigan, Nevada, New Jersey, Oregon, Rhode Island, Vermont, and Washington. At this point, we're going to open it up for some questions and answers. As Tim mentioned before throughout this presentation, you've had the opportunity to ask some questions through the Q&A widget at the bottom of your screen. And we're going to turn to some of those questions now. If you haven't submitted a question but have something you've thought of, feel free to submit it now if you'd like. We've got a limited amount of time here, but we're going to try to get to all of your questions. And if we run out of time, we will try to follow up via email. So the first question we have is there ever a justification for the employer to deny intermittent leave to an employee under this regulation?
Amy, I think I can chime in here with an answer.
Thanks, Colin.
So is there ever a justification to deny intermittent leave? Yes, sometimes is the best answer. If it is going to unreasonably disrupt the employer's operations. So if there is some reason why it would be extremely disruptive to have an employee only work part of a shift or leave early, then in those situations, the employer would be justified in denying intermittent leave. And it looks like we have another question here. Many of our employees are working back in the office, but mostly everyone was working at home at some point. If an employee has an event occur that would be covered under the FFCRA, wouldn't an employer want to allow an employee to work from home instead of making them use paid leave? Can they technically use paid sick leave if they're able to work from home, but the employer doesn't want to allow it? So the key to remember here is that you only qualify for leave if you are unable to work or telework. So if the employee is able to telework, they're not someone who needs to be in the office or in a manufacturing role, the employer can choose to let them work from home. And most of the time, this will mean that they are able to work and wouldn't qualify for FFCRA leave. Now, there are always those situations where, an employee may be having symptoms that are too severe to allow them to work. And in that case, even though they could technically telework, they would still qualify for that leave because they're not actually able to do it. In terms of an employer not allowing an employee to work from home, even though, they have the capability, then they would qualify for leave because they are unable to work from home. If the employer is not letting them work from home, they're unable. John, I think it looks like we have a few questions on the California laws. If you'd like to, let's see here. Does California's COVID-19 supplemental paid sick leave apply to independent contractors?
Sounds like we might have lost John for a minute. In the meantime,
I'm back. Sorry, I'm back. I lost my connection. The answer to that, Colin, is no. California's COVID-19 supplemental paid sick leave law does not apply to independent contractors, but there's a caveat to that, because you need to make sure that a worker is classified correctly as either an employee or an independent contractor under California's AB5 law, which defines who's an employee and who is an independent contractor. So if you misclassify someone as an independent contractor who, in fact, might be an employee under AB5, that person would be qualified to the COVID-19 supplemental paid sick leave.
Excellent. So we have another question here. So if the employer provides or they already have paid sick leave, can they require the employee to exhaust the company's paid sick leave before using paid sick leave under the FFCRA? And that is a great question. You have to allow employees to use emergency paid sick leave before they use any other leave. So you can't require, coerce, or even influence an employee to use vacation time, PTO, or any other leave before using emergency paid sick leave. I think part of the reasoning behind that is that as it stands on December 31st, the FFCRA goes away. Any unused time disappears. You know, the employees aren't entitled to carry it over. They aren't entitled to a payout. And so the FFCRA is written in a way that makes sure that employees can use this leave that will disappear before they use any of their other granted leave.
I think I agree with what Colin said. This is Tim, and I also think that in some respects it might be beneficial for the employer to have them use up their family first leave, because there is the potential that you're going to get credit for the money you're paying there. Whereas I don't know if it's as advantageous tax-wise to make them use up the leave that might otherwise be available to them.
Great point, Tim. Okay, we have another question here. If an employee can work from home and the employer allows it, the employee does not qualify for leave. In other words, the employee cannot choose to take leave instead of teleworking. And that is correct, yes. If the employer allows teleworking, the employee has the ability to, their job allows it, they have the equipment. The employee cannot choose to take leave instead of teleworking. In that case, they would not be unable to telework. They'd be choosing not to, and they would not be qualified for leave.
This is interesting.
Oh, go ahead, Tim.
Oh, I'm sorry. I think this is an interesting question. Would you always designate FMLA while paying emergency paid sick leave for reasons paying 100% if they are otherwise eligible under the FMLA? I think my answer to that would be yes, I think I would. I think you can make a pretty good case that COVID is a serious health condition under the FMLA, even if they hadn't passed this particular law or hadn't passed any law in response to this. And it does seem to me that, you know, you do want the person to be burning off their 12 weeks or part of it. So I would lean towards, yeah, I would go ahead and designate it. Now there might be different opinions here, but I think I would, at least in terms of the federal, FMLA. You know, you might have to sit down and analyze what California is doing and Colorado and all the other usual suspects. But as far as the FMLA goes, I think I would.
Someone asked a question about...
Oh, no,
go ahead, Colin. I see
go.
Another question about whether or not we had anything to discuss about Florida. And I'll just mention, Florida doesn't have an existing paid sick leave law, and they haven't passed anything that is like COVID-19 specific paid sick leave laws. So you'd want to focus on your FFCRA obligations, if any.
Excellent, thank you. I think we have time for at least one more question. John, looks like we have another California one. What liability do I have if I fail to comply with the California paid sick leave law?
That's a good question, Colin, because like most things under California employment law and in the California Labor Code, there are penalties associated with failing to comply, including with the new law. So the California Supplemental Paid Sick Leave Act does allow the California Labor Commissioner to enforce the law, and that includes investigating violations and ordering temporary relief to mitigate violations. Further, if COVID-19 supplemental paid sick leave benefits are wrongfully withheld, employers might be subject to administrative penalties of from $250 a day up to $4,000 in the aggregate. And on top of this, the Labor Commissioner and the Attorney General may bring a civil action to collect these penalties, to seek equitable relief, such as an injunction, seek back pay, and to seek the payment of the sick days unlawfully withheld, as well as liquidated damages. The good news is that right now, at least, there's no private right of action under the new law. But as you probably all know, under California law, we have something called the Private Attorney General's Act, known as PAGA. So an employee could bring a civil action under PAGA to collect benefits and seek penalties under the Supplemental Paid Sick Leave Act. But that has not yet played out in the courts, of course. The law is less than 3 weeks old at this point.
All right, thank you so much, everyone, for participating in our webinar today. If you submitted a question and we haven't gotten to it, we will be following up with you via email. As we mentioned, this is the first webinar in a series, and we hope to see you at the next webinar on October 15th. And if you have a moment of free time, which I'm not sure many of us do nowadays, but if you do, please complete and submit the survey that we'll display at the conclusion of the webinar. And again, thanks so much for participating, and we hope you have a great rest of your Thursday.